A jury awarded John Thompson $14 million. $1 million for every year the state of Louisiana kept him in a cell for a murder he did not commit. He never saw a cent of it. The Supreme Court took it back. In 1984, New Orleans police arrested Thompson for the murder of a hotel executive named Ray Lusa. He was also charged with an unrelated armed robbery. The state tried the robbery first. That order mattered more than anything else in this story. Because the prosecution had a crime lab report, the robber had left blood at the scene, and the lab had tested it. It was not Thompson's blood type. That report was never handed to his lawyers. It sat in a police property room instead. He was convicted of the robbery, and that conviction did something specific. It gave him a violent felony on his record. So when the murder trial came, his own lawyers told him not to take the stand, because a prosecutor would use that robbery against him. He stayed silent. He was convicted and sentenced to die. Thompson spent 18 years in prison, 14 of them on death row at Angola, in a cell by himself for 23 hours a day. 7 times the state set a date to execute him. 7 times. The 7th was scheduled for the 20th of May, 1999. Weeks before that date, an investigator working for his defense went digging through old police files and found it, the crime lab report, the one that said the blood was not his. It had been sitting there for 14 years. The robbery conviction collapsed, and with it gone, Thompson could finally testify at a new murder trial. On the 8th of May 2003, a jury heard the case and came back in 35 minutes. Not guilty. He walked out of the courthouse that afternoon, 19 years after he walked in. There is a gate before any of this, and most people do not know it is there. You cannot sue over a wrongful conviction while that conviction is still standing. If winning your lawsuit would mean the conviction was invalid, you cannot bring the lawsuit at all until a court has already thrown the conviction out, which means the clock on being paid anything does not start the day you were wronged. It starts the day somebody finally believes you. So, he sued, not the individual prosecutors. He sued the district attorney's office itself, arguing it had failed to train its lawyers on a rule every prosecutor in America is supposed to know. That rule has a name. It comes from a case called Brady, and it says the government must hand over evidence that helps the accused, not evidence it thinks is important. Evidence that helps you. Hiding it is not a technicality. It is a constitutional violation. In 2007, a federal jury heard what had happened to John Thompson and awarded him $14 million. It survived on appeal, though barely. The full appeals court split down the middle, evenly divided, which meant the award stood by default rather than by agreement. For 4 years, that was the answer. Then, in March of 2011, the Supreme Court took it away. The vote was 5-4. One justice on one question, and $14 million became nothing at all. The majority did not say the evidence was not hidden. It was hidden, and everyone agreed. The question was narrower and colder than that. Can you hold an entire office responsible for the failures of one of its lawyers? The court's answer was, almost never. To sue a government office over training, you have to show a pattern of failures so obvious the office had to have known and did not care. One violation the court held is not a pattern, even this one. And there was a history. Courts had already thrown out 4 other convictions from that same office for the same kind of violation, hiding evidence the defense was owed. The court held that still was not enough, because those 4 cases involved different kinds of evidence. They did not put the office on notice that it specifically needed to train its lawyers about blood reports, 4 reversals, and it did not count as a pattern. The reasoning was that lawyers are not like other government employees. They go to law school, they pass a bar exam, they carry ongoing ethics duties, so an office can reasonably assume its lawyers already know the rules, and a single lapse does not prove the office ignored an obvious gap. Justice Ginsburg disagreed, and she did something justices rarely do. She read her dissent out loud from the bench. Which raises the obvious question: forget the office. Why not sue the prosecutors themselves, the ones who had the report and did not turn it over? You cannot, and the reason is a case from 1976 called Imbler v. Pachtman, where the Supreme Court held that prosecutors have absolute immunity for their work in the courtroom. That word absolute is doing enormous work. Police officers get something weaker, called qualified immunity, and people argue about it constantly. Qualified immunity is a locked door. If you have exactly the right key, a case that already said this exact conduct is illegal, it opens. Absolute immunity is not a door, it is a wall. It does not matter how bad the conduct was. It does not matter if the prosecutor knew the evidence would clear you and buried it anyway. For the work of building a case and arguing it in court, they cannot be sued personally for damages, and the court has held that shield covers supervising and training the lawyers who do that work too. There is an edge to it, and it is worth knowing where. The immunity attaches to the job being done, not to the person doing it. A prosecutor who fabricates evidence before there is even a case, or who is outrunning an investigation rather than arguing one, drops back down to the same qualified immunity a police officer gets. But the moment they are building a prosecution, the wall goes up. What happened to Thompson was squarely behind that wall. Supporters of that rule argue prosecutors would be paralyzed without it, that every person ever convicted would sue the lawyer who convicted them, and that the job would become impossible. Critics argue it removes the one consequence that would actually change behavior. Both of those arguments are live, and neither has ever won outright. What is settled is the rule itself. And this is not one unlucky man. In a single recent year, 97 people in this country were exonerated. Between them, they had lost more than 1,300 years of their lives. And in roughly 7 out of 10 of those cases, the registry that tracks this recorded official misconduct as a factor. All right. If you cannot sue the prosecutor and you cannot realistically sue the office, then surely there is a fund, something automatic. You were innocent, the state took your life, the state pays you back. There is a federal law that does exactly that. It pays $50,000 for every year you were wrongly imprisoned and $100,000 a year if you were on death row. But read the first line of it carefully. It covers people convicted of federal crimes. Almost nobody is. The overwhelming majority of criminal cases in this country are state cases. Thompson's was a state case. That federal law never applied to him at all. So, it falls to the states, and the states do not agree with each other. About 39 of them, plus Washington, D.C., have a compensation law, which means roughly a dozen states have nothing. In those states, being proven innocent entitles you to exactly $0. And among the states that do pay, the range is not a range. It is a canyon. Texas pays $80,000 for each year. Wisconsin caps the entire claim at $25,000 total, no matter how long you were inside. Run Thompson's 18 years through Wisconsin's formula, and it comes out to about $1,400 for each year of his life. Run them through the Texas formula, and it is $1.4 million. Same innocence, same years, different state line. Some states add one more condition. If you ever pleaded guilty, you get nothing, even if you were innocent. Innocent people do plead guilty, usually to avoid a far worse sentence if they lose at trial. So, the same pressure that helps produce a wrongful conviction can also disqualify you from being paid for it. Which brings us back to John Thompson, and the simplest fact in this entire story. He got nothing. The $14 million was erased, and Louisiana did not pass a compensation law until 2005, 2 years after he had already walked out. There was no fund to apply to. There was nothing. And it is worth being clear about what walking out actually looks like, because it is not what films suggest. There is no automatic check. In most places there is no housing, no medical care, no job placement, and nothing that resembles the support a person on parole would get. Someone released as guilty often has more of a safety net than someone released as innocent. He spent the years afterward running a program in New Orleans for people coming out the way he did, with no money, no record cleared in any practical sense, and nowhere to go. He said, in effect, that he had never cared about the money. What he wanted to know was why the people who hid the evidence faced nothing at all. So, here is where the law actually stands. If a prosecutor hides evidence and it costs you 20 years, you almost certainly cannot sue that prosecutor. You probably cannot sue their office. Whether you are paid at all depends on which state charged you, and whether you ever said the words guilty. None of that is a loophole or an accident. The immunity came from judges. The payment rules came from legislatures. Every piece of it was written down on purpose by somebody, and every piece of it could be written differently tomorrow by somebody else.